Hello, everyone, and welcome to the Labour Justice Barometer podcast. I'm Aisha Adam.
And I'm Debbie Collier.
And we're your hosts today on the Labour Justice Barometer. Welcome back to another episode of the Labour Justice Barometer, and we continue our October mental health awareness series by focusing on the legal protections or the lack thereof for workers facing psychological harm. Today, our guest is Prof. Karen Kalitz, an emeritus professor of law at Stellenbosch University and a long-standing expert in labour law. We decided to discuss her recent article in the ILJ, where she argues that South Africa's current compensation system fails workers, particularly first responders who suffer from work-related mental illness. Karen, you have been one of the leading experts in discussing mental health protection within the workplace, whether it's bullying in the workplace or even burnout. Tell us why you chose to focus on first responders in this article.
Thank you, Aisha. I read the 2023 High Court judgment, Ramanand versus the Compensation Commissioner, in which Mr. Ramanand, as a warrant officer in the South African Police Service, was exposed to scenes of violence and death over a period of 25 years. And in a final trigger event, a suspect shot at him and injured him. He was subsequently diagnosed with post-traumatic stress disorder, causing 100% permanent disablement. He then claimed compensation with the Compensation Commissioner, who relied on a 2003 circular by the Director General of the Department of Labour, which had already been discredited in 2006 by the court in the Udair case. This circular instructed commissioners to calculate compensation for 100% disability caused by post-traumatic stress disorder as only amounting to 65% disability. No reason was given for this discrepancy between physical and mental illness. The commissioner decided that Mr. Ramanand was only 39% disabled, with the implication that he only received a monthly pension of 39% of his previous salary. Monthly salary is something like 25,000 Rand, and he now received something like 15,000 and something Rand as a pension. He objected, but the tribunal rubber-stamped the commissioner's decision, and Mr. Ramanand appealed to the High Court, and the court then held that he was indeed 100% disabled. The court further admonished the commissioner and tribunal for ignoring expert medical evidence, pointed out that the circular by the Director General had no force, as already decided in 2006 in Udair, and further that the tribunal and commissioner misapplied the law, that they did not keep in mind that Mr. Ramanand served his country and employer for 25 years, and that the aim of COIDA is to assist disabled employees, not create stumbling blocks. Well, this claim took 7 years to finalize. And after I've read this, I could not get the grave injustice to Mr. Ramadan out of my mind, especially when I read a similar judgment only a few months later, Felix versus the Compensation Commissioner. This was handed down by the High Court later on in 2023. The facts were almost identical to the Ramanand case. The same circular of 2003 was still used by the Commissioner and Tribunal. Mr. Felix's claim took 12 years to finalize. During these years, Messrs. Ramanand and Felix had to live with PTSD, had to relive their trauma when they testified at the Commissioner and again at the Tribunal, and had to pay their legal costs. The workers' compensation system clearly failed them in several ways. These two cases motivated me to write about the mental health issues of first responders, that is, police officers, firefighters, ambulance staff, paramedics, and other emergency workers. And I learned that a large percentage of them suffer from mental illnesses, such as anxiety attacks, major depressive disorder, and suicidal ideation, but most suffer from PTSD. In fact, the most recent study in the Western Cape, published in February 2025, indicates that 48% of police officers and paramedics suffer from PTSD, while the rate for the general population is only 15.8%. It is disconcerting that research has shown that there is a direct link between PTSD and suicide. In 2015, SAPS Police Service reported that 29 police officers were killed in the line of duty, while 115 died by suicide. And in September 2003, a report by the police union POPCU indicated that more than 300 police officers have died by suicide since 2017. And why are they not supported? One wonders about that. Did they get any support? The problem is that existing employee health and wellness programs in the SAPs are understaffed. Members further do not make use of the programs because of a macho culture in the SAPs and concerns of the members about confidentiality and the fear that mental illness, seen as weakness, will be detrimental to their careers. So I read this and I thought, well, this is terrible. It can't be right. It's an injustice. What can I do? So I thought, well, I'm a labor law teacher and I write, so I will try to write an article about this, and hopefully someone that has influence somewhere will read it.
Corinne, thank you for that. It's a bleak picture that you're painting, and it's an important topic. I mean, we live in a time of high violence and crime, and it would seem that this should have been a priority. Yet it appears, to be the opposite, and it's quite disheartening, really, to hear from you. The status in the sector of first responders. You really are the saints among us who are responding to hostile and violent environments. So maybe just from the perspective of our workers' compensation legislation, COIDA, can you maybe walk us through some of the current limitations in the design of the legislation and also the application of the legislation when it comes to mental illness arising in the context of work?
The current COIDA is more than 30 years old. It was adopted at a time when the focus was on compensation for physical injuries and diseases. The Act does not mention mental illness at all, but the world has changed and mental illness in the workplace is far more prevalent today. Psychiatric disorders have since 2012 replaced musculoskeletal conditions as the main cause of disability claims. Already in 2006, as I mentioned, in O'Dwyer versus Commissioner of Compensation of the Compensation Fund, the claim of a police officer who contracted PTSD was denied by the Commissioner as well as a tribunal because of the Director General circular, as I mentioned. And because Mr. O'Dwyer could not prove that post-traumatic stress disease was a personal injury, his claim was denied. On appeal, the court interpreted COIDA to include mental illness. And not in this case, but in another one, the Urquhart case. Interestingly, it was about a crime photographer, who claimed on the basis of 100% disability or PTSD. And the court then, in that case, said it's as much a psychiatric disorder is as much a personal injury as a cracked skull. And the court also held that this infamous circular had no force. Now, despite the judgment of the Compensation Commissioner in 2023, still relied on the same discredited circular in Ramanant and Felix. And the circular was dated 17 years ago in 2003. So the court in Ramanant pointed out that the constitutional right to access to social security adds to the duty of commissioners and tribunals to assist employees. But if you read this case, it seems as if the commissioner and tribunal, instead of assisting and supporting the police officers, regarded the process as adversarial, in that they had the task of protecting the compensation fund against claims by employees. And the fact that PTSD is not explicitly included in COIDA, and the stigma regarding mental diseases, may have contributed to this bias against the claimants. Otherwise, I can't explain it. The court in Ramanant further remarked that claimants should be entitled to assume that commissioners and tribunals are familiar with the law, which clearly they were not. These cases demonstrate that the training of COIDA commissioners and members of tribunals is inadequate and really should be a priority. The same errors have been repeated over the years, despite severe criticism by the High Court. The courts have found a way to award compensation to employees suffering from PTSD, although COIDA is clearly focused on physical injuries and diseases and not on mental illness. But the problem is the application of the Act by incompetent commissioners and tribunals, and I can add Director Generals as well. Another obstacle for claimants is that they must prove a causal connection between their illness and their job. And this leads to lengthy processes. This, as well as reliving their trauma by giving evidence, exacerbate their symptoms.
You're listening to the Labour Justice Barometer, and we'll be right back.
Would it be your view that, particularly in the context of the causal connection, is this something that maybe should not be a requirement? I mean, just in terms of, you've spoken about COIDA being a dated piece of legislation, what sort of reforms are on the table, and do you think they go far enough? I mean, should we be looking at causal connection differently?
Yes, certainly. But firstly, I want to say that there is hope. The 2022 COIDA Amendment Act provides that PTSD is an occupational disease. For the first time ever, COIDA acknowledges that employees can claim for a mental illness. However, it is disappointing that only PTSD is included in the definition of an occupational illness. So, including mental illness in general in the definition of occupational disease would have allowed for other mental illnesses as well. A challenge for mentally disabled employees is that they still have to prove a causal connection, maybe, as you said, between their illness and their job. unless it is listed in Schedule 3 of COIDA. I'm talking about the current COIDA. Some jurisdictions, almost all states in the US and Australia, as well as most provinces in Canada, have solved the predicament of the first responders by creating a legislative presumption that first responders' PTSD was caused by their job. This prevents long delays and secondary trauma caused by having to relive their ordeals in tribunals and courts. South Africa can learn from these jurisdictions. The COIDA Amendment Act further makes provision for rehabilitation, reintegration, and return to work of disabled employees. The current focus is merely on compensation. COIDA is silent on rehabilitation. A policy of rehabilitation, integration, and return to work involves clinical, vocational, and social rehabilitation, which will be facilitated by the compensation fund. Now, that's the dream. The aim is to keep disabled employees productive and to retain their skills. The measures will counter social isolation, loss of identity, and dignity of employees will be preserved. And according to this Amendment Act, employers must assess risks and mitigate occupational hazards in the workplace. This would include psychological hazards as well and will prevent mental illness. There are also draft regulations published in May 2024 for public comment, and these regulations provide that if a disabled person is no longer able to perform their duties, the employer should accommodate the employee by adapting the employee's duties or looking into suitable alternative work before such a person is dismissed. And as you both know, the provisions of the Labour Relations Act and the Employment Equity Act are also applicable in this context. In these two acts, provision is made for accommodation of disabled employees. Well, the bad news is that neither the COIDA Amendment Act, which has been signed into law in April 2023, nor the regulations are in force yet. The most likely reason is that the compensation fund cannot pay specialists, doctors, occupational therapists, psychologists, or afford devices and facilities needed for rehabilitation. The compensation fund is, unfortunately, scarcely able to meet the claims based on the current COIDA because of corruption, unwise investments, and inadequate electronic system, and also a lack of capacity. Now, so there are many problems, but yes, there's a drive to do something about it. Unfortunately, well, we look at first world countries. I've looked at first world countries and what they do. Perhaps that's not appropriate, but I couldn't really find something in other countries in Africa and so forth. What we should do is to get more money, get rid of corruption, and then we will be able to implement the new COIDA and also these regulations that will make a vast difference to people in the position of Mr. Ramanand and Mr. Felix and all the others.
Thanks for that, Karen. I think it was very useful in your article that you mentioned jurisdictions such as Canada, Australia, the States, something which I think the Global South can definitely learn from when it comes to mental health. And I think based on your experience, especially since you've written on bullying and you've written on burnout, mental health, what we've seen isn't just a personal issue, it's a systemic one. And I mean, it affects how entire professions are treated. Do you think the law is finally starting to take mental health seriously as an occupational harm?
Yes, I think so, Aisha. That's a reason for optimism. There's definitely, as shown by the COIDA Amendment Act and also the regulations, the rehabilitation, etc., there's a move in the right direction. And I'm grateful that the legislature took heed of High Court judgments on compensation for PTSD and also of what is being done in other countries, inter alia the Netherlands, to not only compensate disabled employees, but to bring them out of the cold, to restore their dignity, feelings of self-worth in being productive, and to provide, if only partially, for their own livelihood. I focused on first responders, but there are other vulnerable occupational groups which are at high risk to suffer from mental illness, such as some categories in the medical profession, judges and magistrates, teachers, and surprisingly, those working in arts, design, entertainment, sports, and the media. Mental illness could be alleviated and even prevented by creating safe psychosocial workplaces. The requirements for safety could differ depending on the particular job. And here the Occupational Health and Safety Act, OSA, also adopted in 1993 like COIDA, provides in Section 8 that employers have a duty to provide a working environment that is without risk to the health and safety of employees. Although it is focused on physical safety, the Supreme Court of Appeal held that this, also a common law duty of an employer, includes a psychologically safe workplace. The OZA enjoins employers to assess the particular risks at their workplace. This should be interpreted that the employer has to assess the risks of psychological harm. It will, however, help if this is explicitly stated in an amended OZA. In the case of first responders, this could be maintained, a safe psychological workplace, by rotating the rosters of employees so that they are not constantly on call out, provide rest periods after trauma, address the macho culture in terms of which there's a stigma to mental health problems, and seeking help for mental illness. Until the amended COIDA and regulations could be implemented, training first responders and family members about the effects of PTSD and creating peer support groups could prevent PTSD and suicide.
I think it's extremely useful, and I think it's something that I hope our legislation will actually take into account as we progress when it comes to mental health and protection of mental health in the workplace. And you mentioned about those professions which suffer with the highest rates of mental health illness. When myself and a group of Stellenbosch students actually went to go visit the ILO, the Occupational Health and Safety team lead actually mentioned that one of the highest numbers of depression and mental health illness that she saw in the studies that they did were in labor lawyers, which we all found quite interesting. And it was definitely something that I think, I'm not sure, Debbie, would you agree on that as well, given all the work that they have to witness in the workplace?
Yeah, that's an interesting observation, and I haven't heard that before. It would be good to look into that.
Definitely. Hopefully we can get on to speak about that. But Karen, and our final question, and something that Debbie and I like to do when we speak about our labor justice barometer scale. Green means progress, orange signals that more needs to be done, and red suggests that the law is failing entirely. If you had to look at South Africa's current approach to workplace mental health, particularly in relation to legal recognition and protection, where would you place this?
Well, I think our current approach is in the orange section, and it is slowly leaning towards green, but it will take time and it will take money. So that's my view of it.
I think I would agree. Debbie, what do you think?
I'm very happy to hear Karen's perspective, that we are orange leaning to green. That does leave me with a sense of optimism. So thank you for that, Karen, and thank you so much for not only for joining us today, but for the important work that you've done, throughout your career, in terms of critical issues and highlighting the challenges. Here, in this case, the extent to which we rely on our first responders, they are protecting us, and we should in turn be ensuring that their needs are taken care of. So it's really important work you're doing, and we're very delighted and happy that you were able to join us today and to share your insights. Thank you, Karen.
It was really a pleasure talking about these matters. And I hope that people's eyes will be opened to, as Debbie said, we owe a lot to our first responders. They charge in, what is the saying? They charge in like angels when others fear to tread. And why do they do this? I've read on this, and it is said that they are, well, some of them are adrenaline junkies, of course, because they want to experience this. But most of them are very compassionate people. They feel for their fellow human beings. And we all know that they are not paid a lot. Yes, that is a pity. But we get these unselfish people, and they do it for us, and they look after us, we must look after them.
I think that was very well said. Thank you so much once again, and thank you to our listeners for tuning in. If you found this conversation valuable, please share it with your networks, and all the information that Karen Carlitz mentioned today in the episode will be in our description box, as well as Karen's article, which will be available on the Industrial Law Journal. Thanks again, Debbie, and thank you, Karen. Debbie, I'll see you in the next episode.
Thank you, Asha. Thanks, Karen, for joining us.
Thank you.
This podcast is not intended to constitute legal advice.